New at 4, a lawsuit against the NFL alleging the league endorses dangerous conditions on the fields has officially been thrown out by a judge. Former Denver Broncos linebacker Aaron Patrick tore his ACL on this play in Los Angeles last year. Now, Patrick got his cleats tangled in the cords, the cables, and protective mats near an instant replay monitor when he ran out of bounds. His knee bent back awkwardly as he tumbled to the ground, leading to that season-ending injury. Now, it's just the latest player to try and take the NFL to court over injuries. And Queen City News chief legal analyst Khalif Rhodes here to talk about this case. And Khalif, first of all, what here was Patrick claiming?
Well, a number of things. He's premises liabilities and negligence. And so premises liabilities, this extends to you and me or to the NFL or to that stadium. It's if you invite someone to your property, to your location, you have a duty to make sure that they don't harm themselves or hurt themselves. The other one is just negligence, that you had a duty to protect me. You breached that duty. You were the proximate cause because something that you did hurt me and I got damages. I injured myself. Obviously, tearing your ACL is an injury. And so those are the clear steps. And so that's his argument. That's what he's attempting to argue.
It's common sense by looking at it when you see those kind of cables on the. That's not a normal play of the football, but why or how did the judge say no to this?
The judge said no because, and this is what I would tell any client that comes to me with some type of workplace claim, is did you exhaust your entire remedy that's there, your administrative remedy, I should say. And so if you're a normal employee, not an NFL employee, I'd say, well, did you go through your HR department? Did they allow them to make a claim, or did you allow them to say something? Did you go to the EEOC? Once you've exhausted all those steps, now we can file your lawsuit. Well, in this case, you have the collective bargaining agreement. The collective bargaining agreement specifically says you got to go to arbitration. And so he skipped arbitration and tried to go to court. I would have asked that question in my initial intake. Well, have you exhausted all of your remedies? And the judge said, no, you didn't. Part of his argument is that he didn't want the judge to even entertain looking at the collective bargaining agreement in some other documents talking about the way the field conditions would be set aside. The judge said, no, I'm going to look at both of these documents. And if you look at the documents, it specifically says you have to go to arbitration. He's not saying that you don't have a claim. He's just saying you're at the wrong location. You may have a claim, but you got to go through this arbitration portion first. And there's various reasons you don't want to go to arbitration. Maybe you want a judge to decide it. Maybe you want a jury to decide it. You don't want an individual arbitrator to make a decision. So I can see why, but I'm always having that checklist. You come to me, okay, do you meet the normal steps? Was there a duty? Did they breach it? Do you have damages? Great. Well, did you go through the administrative steps? Well, I actually didn't file. Well, let's go back. Before you even hire me, go through those steps first.
Lawyer should have known that, right?
You would think that he would, but I mean, I think them attempting to make the judge not even look at the CBA, to look at the collective bargaining agreement, that would have at least allowed him to say, I am in the right place. When the judge said, no, the collective bargaining agreement comes in, and I have to read that first, it's clear. It's extremely clear.
And how this affects future cases, though, when you have things like this?
I think for sure, depending on the location. In California, they say you have no state claim, and so you'd have to go to arbitration and you want to go to arbitration. But if you can get outside of going to arbitration and take them to court, I don't think it would have a bearing. First, exhaust administrative remedies. That's what I would say for any future case. Now, one thing that judge noted was California says that you should expect these types of injuries when you're playing, not just the interaction with another player on the field, but even an interaction with cables or cameras and other things like that. They have case law.
Referees throwing flags in people's. I remember that one with the Cleveland Browns football player.
They already have case law on the books for those types of claims. And so this is something that I didn't even understand, that they said this is an intended consequence of the sport that you play, that injuries should be foreseeable. He's saying, no, it wasn't foreseeable. I ran off the field. You see, I twisted my knee like 20 yards off the field. So we'll see how it plays out. It's not over for him, but just in court, it's over for sure.
That is some scary stuff. A very rough sport.
Very rough. You don't think you get injured by some cables. You think you get injured by another person hitting you.
By another person in your head. All right. Chief Legal Analyst Khalif Rhodes, thank you.